We come now to the adjournment. The whip to move.
I beg to move this House do now adjourn.
Thank you. The question is that this House do now adjourn. Mr. Graham Stringer.
Thank you, Mr. Speaker. I'm grateful of this opportunity on the adjournment debate to bring the case of Beth Schlesinger to the attention of the House, and indeed, hopefully, beyond this House, to the whole country. Because I believe that the injustice that has happened to Beth Schlesinger deserves a wider audience and wider understanding than has been the case so far, although it is already a case that has attracted international attention, if my inbox is anything to go by, because I have had emails from the United States, from Italy, from Israel, as well as from Austria, thanking me for bringing the case of Beth Schlesinger to this House's attention. That's the first reason. The second reason I bring the matter to the House's attention is to request the government to take some action on this case. Now, I'm under no illusion that it is very difficult for the government, with the best will in the world. Austria is a modern European country with a judicial system that follows the rules of natural justice, and it's very difficult for any minister from that country, let alone this country, to comment and interfere with the process. However, such is the scale of the injustice that has happened to Beth Schlesinger. I hope the Minister in some way can approach the Austrian ambassador to the United Kingdom or the government to express the concerns and worries that many of my constituents have on this matter. Beth Schlesinger lives in Vienna at the present time, but her parents are my constituents. The only way to describe this case, Mr. Speaker, is Kafkaesque. It's an overused word sometimes in debate, but what has happened to Beth Schlesinger belies normal understanding. Authorities have taken decisions about her life and her children's life which are inexplicable and certainly unjust. I think the best way to explain to the House what has happened is to go through the chronology of events that have happened to Beth Schlesinger. Beth Schlesinger, her maiden name was Alexander, married Mr. Schlesinger in October 2006. On the 24th of May 2009, Samuel and Benjamin, twins, were born to the couple. Unfortunately, the marriage then deteriorated, and Mr. Schlesinger became violent and abusive towards Beth Schlesinger. And on the 15th of February 2010, Mr. Schlesinger tried to have Beth committed to a mental hospital in Austria at the same time, because there had been violence against Beth. At the same time, the police were called and they removed Mr. Schlesinger from the home, from the Schlesinger's home. He was given by the police 5 minutes to pack his bags. A restraining order was placed on him, and he was given limited access to the children. Full custody was given to Beth Schlesinger, and Mr. Schlesinger was given 2 hours access 3 times a week to be supervised. So far, so understandable. Unfortunately, both in this country and throughout Europe, that's not an uncommon experience for married couples. The mother ended up with the custody, the father with supervised access because of his violent activities. Not only had he been abusive and violent towards Beth, he'd also at different times was violent towards Beth's father and Beth's father-in-law. Then things took a turn for the worse. Mr. Schlesinger requested that a friend of his, Constance Fowl, who was a High Court judge in Austria, contacted Susan Gottlicher, who was the judge in charge of the case. After this meeting between the judge, a highly irregular occurrence for a High Court judge to intervene in another court on behalf of a father who had shown himself to be violent, Beth's custody rights were reduced, and the judge ordered that the children were not to leave Austria. On January 2011, on a technicality, the father's access, he was given further unsupervised access to the children. I'm told that was on a legal technicality. If you remember, Mr. Speaker, that originally, after the violent episodes, Mr. Schlesinger had tried to have Beth committed, what we would call in this country sectioned, I suppose. A Dr. Ulrich Villinger then produced a psychiatric report on Beth, where she recommended, without fully examining all the people involved in it, that the children were returned to Mr. Schlesinger's control. That report was considered by the judge on June the 17th, 2011. There was also a report by Dr. Cinco Saz, a qualified psychiatrist, which informed the court that there was nothing wrong with Beth. The children were developing normally. Social services put a similar report in, but unfortunately, Judge Susan Gottlicher, who was the judge who was previously visited by the friend of Mr. Schlesinger's, decided to give full custody to the father in that case. A quite extraordinary decision, and there were no details given in the order as how the handover should happen. On October 2011, and this is a crucial point because these decisions are never carried out, there was an appeal by Beth, and the father's visiting rights, the father's rights were reduced to temporary custody. And crucially, the higher court asked for a further investigation and that reports be drawn up on the children, the father and the mother. This instruction by the higher court was never carried out, and the only reports that were ever produced for Judge Gottlicher's court were on Beth herself. As well as asking for those three reports, the father was told by the courts, and there's a very, as there often is in the German language, a very specific word for this. He was asked to give as much information to the children's mother as he could, so that she could understand all the needs.
The 7 o'clock motion.
I beg to move this House do now adjourn.
The question is that this House do now adjourn. Mr. Graham Stringer.
Thank you. He was asked to basically tell the mother what the children's needs were and what was happening. Instead, what actually happened was that he cancelled 50 of Beth's visits. Rather than him looking after the children, Filipino nannies were hired to look after the children for 12 hours a day at weekend and to take them to and from the nursery. Beth became more and more worried about the children. Samuel had 4 teeth taken out without any medical reasons given. Benjamin had 2 teeth removed. Beth was not only worried about what was happening as the visits were cancelled and the children were upset, it also became clear that in the previous decision of the court, that Judge Gottlicher had suppressed a report from the nursery which had shown and expressed the view that when the children were seeing the father, that they had been crying and screaming and had been extremely distressed. It is quite clear that Judge Gottlicher had that report and it wasn't used. Things went from bad to worse, not just in terms of access to the children, but in terms of financing. Mr. Schlesinger stopped paying maintenance and indeed tried to demand that Beth paid maintenance. She was now only given access to 2 afternoons a week and 3 hours every second Sunday. An extraordinary turnaround from the original situation. In July 2013, the judge awarded full custody to the father. And at this time, and this is absolutely crucial, Mr. Speaker, no assessment of the father, no assessment of the father with the children had taken place. The psychiatrist's report that had recommended against Beth, she had been examined in German, which she is not fluent in, and so her answers had been slow, and that was counted as a mark towards her being mentally unstable. It also became clear that the relationship between Judge Constance, not only with Mr. Schlesinger, but her husband worked in the same hospital as Dr. Villinger. I am not a person who believes in conspiracies, usually, Mr. Speaker, but I think in this case, the decisions that were taken were so strange, one has to suspect that undue influence and conspiracy were taking place. Beth has asked me to bring forward to the House's attention a case of a similar custody issue, much more extreme in many cases, that has been before the higher Austrian courts in the last week or so. A neglected and filthy child, not the case in the Schlesinger family's case, had been taken away from the mother, who was seen to be inadequate. And the higher courts in Austria said, in giving the child back to the mother, a loving child's bond is of paramount consideration. I agree with that. That Austrian court got it right in a much more difficult case than this. They're always difficult in comparing court cases because there are details one doesn't know. But I think that case highlights what has gone wrong in the case of Beth Schlesinger. I just want to thank a few people before I come to conclusions on this case. I have been to see the Austrian ambassador about this, who was courteous and listened carefully and explained the situation to me. The Minister himself has taken a delegation from myself and my honourable friend from Bury South, and I'm grateful to that, and I know he's familiar with this case and sympathetic, and I hope he can listen to what is simply outrageous decisions from the Austrian courts, and even with all the difficulties I explained before, take some action on it. I have great respect for the Austrian state. As a minister, I had regular meetings with Austrian ministers. I like Austria. But on this case, I think the decision that has been taken in Beth Alexander's case is a blight on the Austrian judicial system, and one I hope they will be able to put right. Because brought down to its bare bones, this case is about a violent father who has been violent towards the mother of the children, violent towards other members of the family, being given custody of two children who are clearly unhappy. They do not speak very well at the present time. They were in nappies until they were beyond 4. He has been given custody after undue influence on the courts over a mother who is completely blameless in this case, Mr. Speaker. It is, as a member of this House for 16 years and a councillor for many years before, I have rarely come across a case of such injustice as this. So, with all those difficulties, I'm hoping that the Minister, who has shown that he's interested and sympathetic, can be of help in this case. Thank you. I will give way before I sit down.
To the member giving way just before he concludes, because I want to put formally on the record my thanks to the member for Blackley and Broughton for bringing this case, and indeed on behalf of my own constituent Adrian Alexander, who indeed is the brother of Beth Schlesinger. Adrian and I had cause to visit the ambassador, the Austrian embassy, and we discussed the case with him. And I have to say, I came away with a feeling that even the ambassador was confused about some of the case, particularly in regard to the recent judgment where there's been no recitation of the facts of the case, so we don't even know what we're dealing with. And if we could at least establish that, I think then we could seek some kind of resolution. But I want to formally place on the record, on behalf of Beth's family, the thanks to the honourable member for bringing this to the House tonight.
Those thanks, and as I explained to the House, it's not just Beth's family. There has been concern throughout the world about this case, but I'm grateful for the honourable member's thanks. I'm happy to comply.
The honourable member giving way. This is a case which has caused considerable concern amongst my constituents. At the start of his very fine comments, he commented about the Austrian judicial system following the rules of natural justice. But is he aware that actually in the judgments handed down by the judges, there actually has been no explanation as to why Mr. Schlesinger is favoured over Mrs. They simply issued a judgment with no explanation, and that surely cannot be in line with natural justice.
I'm grateful for that intervention, and I am aware of that the last judgment just said denied, without any explanation at all. There's a great deal that mystifies me about this case, how higher courts' decisions are not carried through, and the inadequate decisions of the lower court. Even though we've got slightly longer than a normal half-hour adjournment debate tonight, one could have taken an hour going through the technical details of the case, but I wanted to really get to the heart of the subject and show the basic injustice that has happened in this case. I'm grateful for the honourable member's intervention.
Mr. Ivan Lewis.
Thank you very much, Mr. Speaker. Can I begin by thanking my honourable friend for securing this adjournment debate and the compelling way in which he's explained this incredibly complex case in a truncated fashion. Can I also thank other honourable members for their concern about a case which I think puzzles those of us who have been involved over a long period of time. I think, Mr. Speaker, we should begin by saying the only thing that matters is the best interests of the children, Benji and Sammy Schlesinger. After 2.5 years in the care of their father, they are suffering from seriously impaired development and appear traumatised. The decision to award custody to the father, Dr. Schlesinger, is one of the worst miscarriages of justice I've ever experienced during my long period as an elected representative. Beth Schlesinger, falsely and cruelly labelled mentally ill and an unfit mother, labels both disproved by independent professionals. A mother, by the way, who is still allowed unsupervised access to her children. If this woman was an unfit mother and suffered from serious mental health problems, the norm would surely be supervised access at the very least. A father, as my honourable friend has said, whose documented history of abusive behaviour has not even been considered by the relevant court. A senior Austrian judge, Constance Tau, a friend of the father's family, who sought to influence the judge hearing the case on behalf of the father. And an element to this case that my honourable friend didn't mention, a senior social worker, Dr. Kindelhofer, who testified to the mother's positive parenting skills and expressed serious concern at the integrity of the legal process, who has been intimidated and threatened with the loss of her job, and as a consequence of that, is no longer willing to express an opinion on this case. A final decision, as my honourable friend has said, made by the Austrian court, that the father should be awarded custody without any independent professional assessment of the father, the children, or the interaction of the father with the children. And despite the fact, and this is not generally known, that one of the children has been referred for professional help because that child is self-harming at such a tender age, and despite the fact that child protection agencies have been called to the father's home following reports of children crying endlessly in an unusual way in distress, despite all of that, the court made a final decision with one word. That one word, refused, i.e. the appeal in this context. Now, I want to end by saying this, Mr. Speaker. As my honourable friend has said, it is ordinarily incredibly difficult for a government, any government, to intervene in the justice system of another country. I can testify to that as a former Foreign Office Minister. And the default position, I hope people will take this in good nature, the default position of the civil service in the Foreign Office is not to involve themselves in civil disputes of any nature. That is the default position. That is the advice that the Minister will be given, I'm almost certain. What I would say to the Minister, though, this evening, and I say this, he's been incredibly sensitive in the way that he's dealt with this case previously and offered to provide an element of assistance on behalf of the Foreign Office. At that time, the relevant solicitor for Beth Schlesinger advised that that would not necessarily be helpful. I'm afraid that is long past now, and the family are very clear, and I think their current legal representative, that any assistance that the UK government could give would be welcome and could indeed make an element of difference. So I think what we are asking the Minister to do this evening is to raise this case, as my honourable friend said, with the Austrian ambassador to the UK, to raise this case through the relevant channels with the Austrian Justice Ministry, and to ensure that there is a comprehensive review of this case undertaken, and if possible and where appropriate, the case be reopened. We are realistic enough to realise it would be entirely inappropriate for the UK government to instruct the Austrian Justice Ministry or Austrian courts in terms of the decision that they ultimately make. But there is absolutely no question there are serious issues to be addressed in relation to a flawed process, and as my honourable friend said, I would go even further, in relation to corruption. Now, the Austrian justice system is not renowned for corruption. It is viewed to be a modern, a transparent justice system. But in this case, there are so many questions to answer. I think it is entirely appropriate for the UK government to ask the Justice Ministry to look at the case in all of its elements and to reopen the case as a matter of urgency. And the very final point I would make is the earliest years of children's lives are the most important. The Speaker knows this perhaps better than most. He's done a tremendous amount of work in recognising this in a different context. One makes the most difference in the earliest years of a child's life. And that is why also there is no time to waste. Anyone who has seen these children, who has met these children, who has observed these children, is extremely concerned about their lack of development and their apparent traumatisation. And in those circumstances, I think we all have a duty to act. Thank you, Mr. Speaker.
I call the Minister of State at the Foreign and Commonwealth Office to reply to the debate. Mr David Liddington.
Mr Speaker, can I first of all congratulate the honourable gentleman, the member for Blackley and Broughton, for securing this debate and for the way in which he spoke with such clarity and passion about the case that he was putting forward on behalf of Ms Beth Schlesinger. And I would want to acknowledge too the long-standing interest in this case by the honourable gentleman, the member for Bury South, and the interests of my honourable friends, the members for Hendon and for Golders Green and Finchley, who have intervened at an earlier stage in this evening's proceedings. Now, it is a sad fact of life that international custody cases are becoming more frequent, as in today's world more parents of different nationalities marry and bring up children. Marriages or relationships, sadly, sometimes collapse. And while in many cases arguments about the care and custody of the children can be settled amicably, in an increasing number of such cases, we see parents going before the courts to argue about who should have custody or in which country the children should reside. In more extreme but increasingly common cases, one parent absconds with a child without permission, an action that can quickly escalate into charges of abduction and arrest warrants being issued. Now, this case is different from those. In the cases of child abduction, it is our standard practice in the Foreign and Commonwealth Office to urge parents to look to the Hague Convention to provide them with the way forward, and the Hague Convention, as the House knows, provides a mechanism by which to determine in an international dispute over custody which country the children, in which countries' courts the children's future should be determined. Now, if I can turn to the particular case that we are debating this evening. Ms Schlesinger is a British national and her husband an Austrian national. They both currently live in Austria. Their children were born in that country in 2009 and have lived there ever since. And that is why this custody case has been heard by the Austrian rather than by the United Kingdom courts. Ms Schlesinger contacted my office just this week to outline her concerns about the welfare of her children, concerns that the honourable gentleman, the member for Blackley and Broughton, described in some detail. I was somewhat reassured to see that she has the support of her family, friends and of specialist non-governmental organisations such as TAMBA, but I'm the first to acknowledge that both her separation from her children and her consuming anxieties about their welfare make this an incredibly difficult time for her. And I want, Mr Speaker, to explain the government's involvement in supporting Ms Schlesinger to date and then move on to how we see the case today. In February 2010, Ms Schlesinger's father visited the British Embassy in Vienna to discuss his daughter's situation. Divorce and child custody proceedings were at that time taking place in the Austrian courts, and Ms Schlesinger was clearly concerned that her husband might prevent her from returning permanently to the United Kingdom with the children following the breakdown of their relationship. At that time, the embassy was able to assist by providing our list of English-speaking lawyers in Austria and information on both local women's support organisations and international organisations with relevant experience. Our consular staff explained that in cases where families could not agree custody arrangements for the children on their own, it would be for the courts to decide which parent should retain custody and where the children should be resident. Our staff also explained that both the United Kingdom and Austria are party to the 1980 Hague Convention on International Parental Child Abduction. That means that both our countries have agreed that where there is an international dimension to custody disputes, it is the court in the country where the children normally live which is best placed to make a custody decision in the best interests of the child. Now, in this case, for the reasons I have described, the children were born in Austria and they have always lived in Austria. This is the Austrian courts. And in July 2011, as the Honourable Gentleman explained, the Austrian courts awarded custody of the children to their father, Michael Schlesinger. Now, when parents' relationships break down and they cannot agree where a child should live, the resulting custody case inevitably causes untold distress to everybody involved, from the children themselves and both parents to the extended family. And that distress can only be amplified when large geographical distances separate or threaten to separate one parent from the children. But as I did explain when I met the Honourable Gentleman for Blackley and Broughton and for Bury South in July last year, while there is no doubt this is a deeply distressing case for Ms Schlesinger and her family, there is limited scope for the Foreign and Commonwealth Office to intervene. Our staff are not legally trained and therefore cannot offer legal advice. We help instead to put British citizens in touch with reputable and, where possible, English-speaking local lawyers who are familiar with local laws and procedures and best placed to offer professional advice and support on the case and to identify any procedural irregularities with the court process in the country concerned. Nor, the Honourable Member for Bury South was right about this point, can the United Kingdom interfere in the independent judicial process in another country, just as we would not stand for another country interfering in our own independent judicial proceedings. Now, when I met the two Honourable Gentlemen in July last year to discuss the case, I explained that background and that custody disputes are private legal matters, where if the parents cannot agree on arrangements for their children, then the decision on what it is that is in the children's best interests must be made by the courts in the country where the children are habitually resident. It will be very clear, Mr Speaker, to the House this evening that from what the Honourable Gentleman opposite has said, that he and Ms Schlesinger have deep concerns about the integrity of the legal process that has taken place in Austria, and believe too that some of the information and the evidence presented to the Austrian courts may have been seriously flawed. Ms Schlesinger does need to address these concerns with her legal team and consider what options there are to pursue these through the Austrian and potentially the European legal system. While the Foreign and Commonwealth Office cannot become involved in the competent judicial process of another country, if Mrs Schlesinger's legal team were to approach us with significant and substantiated, and I stress that word, concerns about the process that had been involved in this case, we would certainly be prepared to consider such representations and consider raising them with the Austrian authorities. Our embassy in Vienna has provided some assistance to Ms Schlesinger and her family since that initial contact in 2010. As well as the lists of lawyers and of support organisations and international bodies such as Reunite, the Embassy has, during the course of this case, contacted the judge on some practical questions about timings and provided a statement to Ms Schlesinger's lawyer at the lawyer's request. There had been no direct contact between Ms Schlesinger and our consular staff between May 2012 and now, but in all our contact we have consistently advised the family that this has to be a matter for the courts to determine, and I have given this advice to a number of honourable members and other interested parties in 2011, 2012 and 2013. Ms Schlesinger and her family have asked for the FCO to intervene in order to raise concerns about the court process and to lobby the Austrian authorities for her to be given custody of her children. Now, I have to be clear, Mr Speaker, that we can only intervene if there are sufficient grounds, particularly substantiated grounds about the process involved, and we cannot simply take sides regarding the custody of the children, any more than government ministers can take sides in such a dispute being handled by the courts here in the United Kingdom. Ms Schlesinger's lawyers' concerns have previously been dismissed by the appropriate judicial authorities. When I met the two honourable gentlemen opposite, I did agree that our officials should make contact again with Ms Schlesinger's legal team, and we took that step. The lawyers' clear advice to us then was that any form of diplomatic intervention could prove detrimental to their case, which was at the appeal stage at that time. We therefore stepped back from any repatriation and considered instead whether we could do anything to expedite progress in a hearing. Now, if lawyers have changed their view and can bring forward some substantiated evidence of something going seriously wrong in the process, again, I say we will examine those representations. Since then, Ms Schlesinger has taken her appeal to the Austrian Supreme Court, who have said that it is inadmissible. I can understand, having listened to the honourable gentlemen, the members for Blackley and Broughton and for Bury South, that the somewhat terse language used by the Austrian Supreme Court must indeed have upset Ms Schlesinger deeply, and the absence of any detailed explanation would have made that decision even more difficult for her to bear. I'm aware too that no words I or anybody else can speak tonight are going to console her, but given the huge emotional and, besides that, enormous financial burden that this case will inevitably carry. But I believe it is crucial that she now discusses again with her new lawyers how best to proceed from here, whether there are any further avenues within the Austrian legal system, and also whether she needs to consider the European courts, perhaps especially the European Court of Human Rights. The United Kingdom's ambassador to Austria has agreed to meet Ms Schlesinger this week to consider whether there is anything more that he is and his team are able to do beyond what they have already undertaken. But the root of this dispute are the allegations of irregularity in the court process. So any evidence of procedural irregularity should be pursued by legal means in Austria, and I cannot emphasise too strongly our view that Ms Schlesinger should seek immediate legal advice following the recent decisions by the courts, and if her lawyers advise that there are grounds for diplomatic intervention that might be of benefit and which could be substantiated by sufficient evidence, then the legal team and or the honourable gentlemen are welcome to come and put their representations to us again. Like any parent, I feel nothing but heartfelt sympathy for Ms Schlesinger in the plight which she faces. I'm sure that every member of this House hopes that this case can be resolved swiftly, amicably, and above all in the best interests of the children.
Order. The question is that this House do now adjourn. As many as have that opinion say aye. Aye. If the contrary, no. I think the ayes have it. The ayes have it. Order. Order.